Mr. Evans, the state is tendering a dismissal. They're saying it's for missing witness, not for insufficient evidence. Do you understand?
Yes, Your Honor.
So I don't know what brought you here other than the charges that you have. But if there is some sort of issue that's going on with you, you need to correct it. Otherwise, you're going to be back in someone's criminal court. You understand?
Yes, Your Honor.
And Your Honor, I'm requesting if the court would make the dismissal with prejudice so that we could do an immediate expunction. There were issues with the stop, which we're talking about doing a motion to suppress on, but they decided to dismiss because they were not able to get the information subpoena that you ordered them to subpoena last setting. And I just want to make sure for my client that I can do an immediate expunction for him.
I am not going to grant a motion to dismiss with prejudice.
Okay, thank you, Judge.
You're welcome.
I just want to get my thoughts organized here.
Sure.
At our last hearing on this case,
Mhm.
You ordered the state to subpoena the information that was missing.
Mhm.
They did not subpoena the information that was missing. They didn't initially say, yeah, we're going to dismiss this case.
I'm sorry, just if you could hold on a moment, that's good. The printer is running and,
I understand. I
All
have
right.
that problem too.
all right, yes.
Maybe we should put this on record.
Sure, you want to bring your client up?
Yes, Mitchell Evans.
Can I see the file on Mitchell Evans, please? Court is calling 2023 CR 6408 State versus Mitchell Evans. Can I have parties announced for the record for the state? For the defense?
Linda Corley for Mr. Evans.
And are you Mr. Evans?
Yes, Your Honor.
All right. So that the record is clear, the state tendered a dismissal, and that dismissal was based upon a missing witness. The court signed the dismissal, and the defense asked that the case be dismissed with prejudice so that her client's case could be expunged. The court denied the defense's motion to dismiss with prejudice. Defense, and there's something you wanted to put on the record?
Yes, Your Honor. When last we were at court, the last hearing, Judge, you ordered the state to subpoena some missing discovery that we've been trying to get since, I believe, the court had noted on the record last fall, I think October or November. I'm not sure on that date. We came back to court today. The state had not subpoenaed the information. I also talked with the prosecutor and he was unwilling to dismiss the case.
The lawyer tried hard to sound smart, tossing fancy words like immediate expulsion and motion to suppress, but the judge wasn't buying it. Calm and sharp, the judge shut it down with a simple, "Not granted," proving that experience beats drama every time.
And
I'm sorry, could you repeat that last
he
thing?
was unwilling to dismiss the case, feeling that it was a case that might be good for a motion to suppress. However, he didn't feel that it should be dismissed. And after further consultation, I guess amongst themselves, they decided to go ahead and dismiss the case based on what was first marked as a further investigation, which I had issues with. And so it was, after discussion between the prosecutors, changed to missing witness. Judge, what I don't want to have happen to my client is to have the prosecution do a workaround to give themselves more time to get information that would have otherwise probably been suppressed and then go forward with the case. That's my
State, are
concern.
you, on the record, are you planning to re-indict this case or refile this case? All right, so the state has no intention to refile this case?
Yes, and I.
Wait,
I'm
just a
sorry.
second. So state has no intention to refile this case? All right, you may proceed.
I'm sorry. And I am definitely not disparaging our prosecutor here. She has actually, as far as I know, she's reached out to China Grove multiple times and they have completely ignored her. But they did not issue a subpoena. And at the last hearing, we specified it was for the officer, that he would have the information about the call. So they did not subpoena. I guess, Judge, I'm just in an abundance of caution. I would like for you to rule on, I would ask that just in case anything happens, prosecutors change, I would like for that information that was to be subpoenaed, specifically the information about the call and the additional, all of that the officer put in his report, I would like for that to be suppressed, just so that in the event that something does happen, in this case does get refiled, they didn't get to do a workaround because they didn't follow the court's order.
All right, so what the court will say on the record is, as far as the court making a ruling on a motion to suppress, the court does not have a motion to suppress before it, so the court cannot suppress any evidence. I don't even know what the evidence is. The state has stated on the record that they have no intention of refiling this. I would think probably the best thing to do is to ask the court reporter to print off this record where the state said that they will not be refiling this.
And Your Honor, if I may?
Yes.
I'm not asking you to grant a motion to suppress that hasn't been heard. What I'm asking you is to suppress information that was not properly disclosed under 3914 in a reasonable amount of time, and that is an option that, and a resolution that has been used by courts before whenever information was not provided under 3914 properly, that information was suppressed as the remedy.
All right, so it is hard for the court to agree that some information should be suppressed when I have no idea what the information is. Sometime the remedy is defense is allowed an opportunity to review the information, maybe call different witnesses if need be. But for the court to enter a suppression of evidence that the court hasn't seen, I'm not going to do that.
So there it was, the lawyer giving a full courtroom TED Talk, circling around motions and subpoenas like they were magical spells that might suddenly make the judge forget the rules of law. Meanwhile, the judge sat there, calm and collected, probably wondering if this was a hearing or a creative writing exercise. The lawyer kept talking about evidence no one had even seen, and the judge, in peak professional fashion, just dropped the truth bomb.
It's not information that's unknown. And I appreciate your patience with me, Your Honor.
No.
It's not information that's unknown. We know what it is. We know that the officer said that he received a call on his cell phone giving information about a car that was driving recklessly. And so we know what that is, but we don't know who the caller was. And so the order was to subpoena to get the information about the caller. So we know exactly what the information was, and they failed to get it. We've been trying to get it since last fall, and so that would be a violation under 3914, and a normal remedy for that, because the 3914 really doesn't have any teeth in it. The only remedy we have is then for the court to say, well, you can't use that information if it was to go forward. That information is suppressed. You can't use it because you didn't abide by 3914, and that's all I'm asking the court to do.
All right, anything from the state?
The judge just found an agreement. I've already stated that we follow the ultimate annotation in the system.
And again, Judge, this was just an abundance of caution to represent my client effectively.
No. I appreciate your arguments. The court is going to deny your motion. My suggestion is that you obtain a record from the court reporter. Cindy, if you'll make sure that she has a copy of this hearing, and you just need the portion where the state said that they would not be refiling this case. And then if need be, if you need to call me as a witness, I will come as a witness if they refile it.
Thank you, Your Honor.
Without subpoena, well, I'll need a subpoena, but just know I will come and I will testify.
Thank you for your patience.
And that's how the courtroom wrapped up. The lawyer still pushing every legal button available, desperately trying to sound noble in an abundance of caution, while the judge kept their cool like a seasoned pro dealing with a never-ending debate club. The judge politely shut it down. It was the perfect mix of patience, authority, and a touch of dry humor that said, "Nice try, counselor, but this show's over."